Thank you, Amel. Good evening, everyone. Thank you all for coming. When Amel asked me to participate in this event, she suggested I should offer some reflections on my legal and judicial career. And one of the drawbacks of becoming the first woman in a certain position is that you do find yourself somewhat constantly asked to speak about the route that took you to this point and sundry encounters along the way. There is a real risk that such an approach leads to a my life and times account, which the achievement, such as it is, does not merit, a bit like Adolf Hitler, My Part in His Downfall by Spike Milligan, but a lot more boring. I am really going to try to avoid that trap, but there is some merit, I think, in going over a touch of ancient history, if only to draw a comparison with where we are now and where we may get to in the future. The other drawback, of course, of returning to the same subject, danger of repetition. I fear many of you may have heard this before, or some of it, so I apologise sincerely to any of you who have trod this path with me on a prior occasion. As I imagine you all know, the office of Lord Justice Clerk dates back to the 14th century. You may not be so familiar with the fact that of previous holders of the office, one was murdered, another was a spy for Cardinal Richelieu, a third had his wife violently abducted and forcibly banished to St Kilda, where she was held in captivity for about 10 years, and the most notorious, of course, thanks to Coburn's unflattering pen portrait of him, was Braxfield, the model for Stevenson's Weir of Hermiston and who presided over many of the sedition trials. In Coburn's words, he was destitute of principle and character, unscrupulous, tyrannical, coarse, dissipated, illiterate. He was morally almost featureless. He had a hard heart, a tainted mind, a cross-grained, domineering nature, and an uncouth exterior. A noble aspiration or a lofty motive he was incapable of appreciating. Without faith, without hope, without charity, he moved continually in a world of sordid interests and ignoble purposes. He was coarse and jocular when he ought to have been dignified and circumspect, vindictive when he ought to have been dispassionate, cruel when he ought to have been just, boisterous and domineering when he ought to have been serenely calm. He doesn't look quite so bad in the portrait, really. And I dare say that we have to allow for some exaggeration on the part of Coburn, whose Whig sympathies were notoriously not shared by Braxfield, but on any view not the sort of person who would appeal, I think, to the Judicial Appointments Board for Scotland for judicial preferment, far less to one of the great offices of state. Anyway, the many holders of the office were obviously, from what I've said, a rum and a sorted lot, but they did have one thing in common. They were all men. It took at least 700 years of the existence of the office before a woman was appointed. When I called to the bar in 1981, I was one of 4 women calling that year, 1 in the spring and 3 in our calling group, out of a total of 11 admissions. In turn, we brought the number of practicing women up to about 11. It was another 10 years before any of the women juniors already in practice before our group took silk. And generally, progress in numbers was fairly slow at that time, before finally picking up a fair bit from the late 80s onwards. The profile of the solicitor branch of the profession was no better. When I did my post-qualifying year as a solicitor, there were only 2 women in Edinburgh Sheriff Court doing regular defence work, myself and the late Joyce Powrie. I don't think we looked at all similar, but nevertheless, certain sheriffs, men, inevitably, got us mixed up. These kind of irritations apart, and I've said this before, it may be that I have a particularly sunny or optimistic take on life, or it may be that I simply block out any untoward experiences. But if you expect to hear lengthy tales of woe and sexism, you won't hear them here. It is true that the ladies' robing room was at the time a small cupboard-like room down several steps of stairs in the bowels of the earth, next to the generators, opposite the condemned cell, and close enough to the kitchens to smell permanently of cabbage. But it didn't take too long to get that sorted out. There were other issues which arose from the kind of automatic and unthinking assumption that an advocate would be a man, but less in the way of direct sexism. I think also that by the time of my admission, we were just starting to gain a slight benefit from numbers, a very different state of affairs which had faced some of the called in earlier times, particularly people like Dame Margaret Kidd. 11 might not be very many, but in a very bar, which it was then, it's at least verging on statistically significant. And that's a point I'll come back to later. What I do remember is not so much the issue of sexism, but an obsession with seniority and status. Senior QCs objecting to my presence in the gown room in Glasgow, not because I was a woman, but because I was only a devil. There was a devil's table in the library, and to many members of faculty, devils were basically invisible. Even after calling, when a crowd of advocates was leaving the library in the morning to head for the gown room to change, you had to do a quick calculation in your head to work out who was senior to you, so that they could go out first and you could follow behind them. It was all a bit farcical. The other obsession was with the dress code. That's something I fell foul of entirely by mistake before Lord Johnsey when I went into court wearing a pink, Schiaparelli pink tie it was. And I thought it looked rather fetching. I would normally have taken it off before going into court, but I was in a rush and I had forgotten. Lord Johnsey indicated that he couldn't hear me. I thought at first I'd perhaps forgot to put my wig on, but no, wig was there. And then I saw the flash of pink, realised, and took it off, and all was well. But it caused a bit of a furore, and it was rather ridiculously picked up by several newspapers, where it morphed into a red scarf. And it's something that's followed my every move. Whenever anything happens or I'm appointed to something, out gets trotted the story about the red scarf. That's why, in the portrait in Parliament Hall, I am wearing a red scarf. Can we see it, Susie? Yeah, there we go. The obsession with the dress code continued beyond my contretemps with Lord Johnsey. In what must have been about 1985, one senior and very elderly judge had complained to the then Dean, Willie Prosser, about one of my colleagues having appeared in an outfit which was more décolleté than he considered appropriate. The Dean made the mistake, instead of raising the issue quietly with the individual in question, of writing to all the women, every single one at the bar, expressing the complaint in general terms. Well, talk about furious. We were incandescent. We had a quick meeting of those of us who were in PH that day, and we examined our outfits. And I kid you not, a more demure bunch you would have been hard to find out with the confines of a nunnery. We decided, therefore, to make our complaint in turn to the Dean, objecting in the strongest terms at the letter which had been sent to everyone. Astonished heads turned in the corridor as we marched in single file along to the Dean's office. Given who the Dean was, he was immediately apologetic, but also found the whole thing highly amusing. I wish I had a camera, he laughed. No sooner said than done. For reasons now forgotten, Gail Patrick had a camera in her bag, which she immediately produced for us all to be captured on film. And here we are. I think you'll agree we could not be more demure if we tried. So we were absolutely furious about that. Anyway, returning to the theme, the unthinking assumption that advocates would be men continued when I was appointed as the first woman advocate deputy in 1988. My commission appointed Leona June Dorrian as an advocate depute to represent the Lord Advocate in all sorts of ways, granting all sorts of powers to him. I sent it straight back and got a new one from a somewhat mortified Lord Advocate. It had obviously been churned out on a word processor and nobody had bothered to check it. In one way, I can almost understand the automatic assumption being made. After all, there were 4 advocates clerks, they were all men. The faculty office bearers, all men. The judges, all men. The clerks of court, all men. As were the macers and the prosecutors, they were all men. We've got a couple of old pictures of the court, one of the Court of Session and one of the High Court, and that's the Court of Session. And these are from the mid-19th to late 19th century. 100 years later, it was still like that. All men, all the way through, on the bench, at the bar, everywhere. I have no family members in the law, other perhaps than on the wrong side of it, but I knew from a young age that I wanted to be an advocate, and I remember quite clearly deciding at the age of 13 that that's what I wanted to do. I think we've got the other picture as well of the High Court, if you want to put it up, just for people's entertainment. Susie, thank you. And there were 2 major influences behind that decision of mine, one from life, and one which shows the significance of popular culture, and oddly enough, they were interconnected. The influence from popular culture was from the television. It was specifically an actress called Margaret Lockwood, who played the part of a woman barrister called Harriet Peterson in a programme called Justice. Lady Peyton's about the only person in the audience probably old enough as I am to remember it. The rest of you, I think, will be unaware of it. But it was a programme that really gripped me. She was playing the part of a criminal barrister. The storylines were all different and exciting. The life was so interesting. The court scenes were thrilling and gripping. And there was a woman making her way at the centre of it all. I was completely hooked. And it turns out that the real life influence was in fact, the real life influence on me, was in fact the career of the woman on whom Margaret Lockwood's character was based, namely Rose Heilbronn QC. It's almost difficult to credit now, but in the 50s and 60s, she was probably one of the most celebrated women in Britain. She was certainly the most celebrated woman in the law, if you exclude Ruth Ellis, the last woman to be hanged. Rose Heilbronn, and we have a photograph of her, there she is, when she took silk. She was the first woman to make a real career of life at the criminal bar, right at the grittiest, darkest, most masculine heart of a male-dominated profession. There she was. In the 60s, she was in the newspapers daily. This is absolutely true. She was in every newspaper. She became the Daily Mirror's Woman of the Year. She was quite literally a household name, and she conducted many of the really, really big criminal cases of the day. She was the first woman to lead in a murder trial in England, and indeed, I can confidently say in the UK. She won her first acquittal on a murder charge at the age of 29 in 1946. That was at a time when murder was still a capital offence. She took silk in 1949, and she went on to save many more poor wretches from the gallows. A couple of years before I went to university, she became the first woman to preside over a trial at the Old Bailey as recorder, and it's generally acknowledged that had she been a man, she would have been appointed at a much earlier stage. The year after that, she was made leader of the Northern Circuit. That was 1973. A woman was actually made leader of the Northern Circuit. It was a pretty astonishing achievement, and the influence it had on one Edinburgh schoolgirl planning to study law was immeasurable. Of course, unknown to me, at the time, Margaret Kidd had forged her own career first here in Scotland, including becoming the first woman to take silk, not just in the UK, where she beat Rose Heilbron by a year, but in the whole Commonwealth. She was appointed to a post that's really equivalent now of Sheriff Principal in 1960, having followed a successful career at the bar since 1923. But it wasn't the headline-grabbing, kind of glamorous career of Rose Heilbron, so until I learned about it later, when I came to the bar, it had rather passed me by. Margaret Kidd was admitted in 1923, and she took silk in 1948. In 1949, Isabel Sinclair was admitted. So you can work that out. As soon as one takes silk, another is allowed to become a member. That's the kind of progress that we're talking about in those days. She was made silk in 1964, and those with arithmetical acumen will work out again that that's 25 years before she took silk. And she was appointed as sheriff in 1968, so she was no longer in practice when I was admitted, or even when I started my apprenticeship. Her great achievement in becoming the second woman in Scotland to be made a QC, one of still only a handful in all of the UK or the Commonwealth, was met by a headline in the Glasgow Herald distinguishing itself with the words "Housewife QC." I know, it makes you weep, doesn't it? She was actually once upbraided by the court. I don't think it was for what she was wearing. I think it was for wearing red lipstick. There's obviously something about the colour red, but can you imagine it, being brought to task for wearing red lipstick? Hazel Ernson, who had been admitted in 1964, following the pattern, same year that Isabel Sinclair took silk, another one's admitted, another one's allowed in, and she became a sheriff in 1979. I appeared in front of Hazel quite a few times when she was a sheriff, and it was a great day when she was appointed to the High Court bench in 1996. Having been a temporary High Court judge since 1992, she was the first woman appointed to the High Court bench in Scotland, and she was also the first to be appointed to the Inner House in 1993, where she served with great distinction. I think, and I suspect others will agree with this, that a seminal moment came really in 1976-77 when there was a group of about 4 women admitted, and that actually took the number of practicing women, it virtually doubled overnight. The upshot being then that we now had a core group of women determined to practice and make a career of it, as they all did. Lady Peyton sitting there was one of them, along with Laura Smith, Susie Rayburn and Linda Clark. And I think that really made the big difference when the 4 of you were called and all practicing at the same time, and bringing the number up, doubling the number, was, I think, the critical tipping point. And it made it much easier for those of us who were admitted later in 1979, 1980, 1981, during which period a total of 6 women were admitted. And it built on the work of those such as Hazel, who had pioneered before them, and enabled us only a few years later to embark on our careers in a context where the idea of women being admitted to the faculty and establishing a practice was no longer considered quite such a rarity. I think that made a really big difference, and I'm more than happy today to acknowledge that considerable debt. And that takes me on to the subject of mentors and role models. A recent study in the LSE, I think it was last year, reported the less than astonishing fact that the offspring of doctors are 24 times more likely to become doctors than others. The offspring of lawyers are 17 times more likely to become lawyers. The same applies in other fields. Those whose parents are in the film industry are 12 times more likely to follow a similar course, and for journalism, they're 6 times more likely. Now, none of this is at all surprising, but it does graphically illustrate the importance of role models Having a member of a profession in the family, or even as a close family friend, normalizes that profession as a future career path, as a potential career path. It makes it appear to be a reasonable, realistic, and attainable career option in a way which simply does not exist for those who have not benefited from that normalizing effect. Moreover, it gives you what the study refers to as cultural capital. It gives you an understanding of how the system works within a profession, does what within it, and so on. It helps you understand the difference between an advocate, a solicitor, an advocate depute, or a GP, a surgeon, a physician, a consultant. These are very important considerations, making it appear at least familiar and attainable. And you can readily see how someone without these advantages may be less likely to consider a career in the law or medicine or whatever it is as a viable option. We are perhaps at last seeing the many changes within the profile of the profession over the last 40 years starting to be felt at the judicial level, at least in respect of women. We have some way to go in relation to other minority groups, but the issue which I've been addressing, normalization, the effect of role models, mentors, and the impact of increasing numbers and the way that may have an impact on visibility and thoughts of attainability, I think are not relevant only to the efforts of women, but apply with equal force in respect of other underrepresented groups. Improvement of all of these aspects is critical to making a career in the profession appear reasonable, realistic, and attainable for all other underrepresented groups. I think I'm going to move on from the changes within the profile of the profession and the judiciary to changes in how court business is managed and conducted, because that's another area that's changed a great deal. Looking back on much of my early career, I think I'm looking back on an entirely different world. In some respects, it seems like another planet. If I went back in a time machine, I don't think I recognized the place or the laborious and time-consuming work practices. Notes, pleadings, opinions were frequently written by hand, as were all court minutes and fee notes. The court still sat on a Saturday morning to hear divorce cases. Nobody had a computer or a mobile phone or anything. Judges all seemed ancient. They appeared, to some extent anyway, remote and forbidding. I think they probably were actually older on appointment than judges today tend to be because of the intervention of the war. You know, 6 years intervention of the Second World War had caused something of a hitch in their careers, so maybe they were older. But the idea that I might one day be amongst them would have seemed laughably impossible. The appeal court of the day was so fierce there was a club of advocates known as the Hole in the Head Club, whose efforts in the appeal court had achieved the rather unfortunate effect of increasing their client's sentence rather than reducing it. The club emblem was a wig with an axe cleaving it in two. And I regret to say that I am a member of that club, and Francis McMenamin joined it on the same day and in the same case. Juries were secluded as soon as the speeches were finished. They were sent to an hotel overnight with instructions only to resume deliberations the following day. Many of you will know the story of the long terrorist case when the jury were in the hotel for several nights. The trial had lasted 5 or 6 weeks, and naturally the jury had become a friendly unit, which happens actually very quickly, I think, with juries after only a couple of days at most. I think it's an example of the Stockholm syndrome. Anyway, on the first night in the hotel, 2 juniors shyly approached the somewhat stern clerk of court McNish to ask whether it would be objectionable if they shared a bedroom. No, said the clerk, just make sure you don't discuss the case. Somehow, I don't think that's what they had in mind. We now live in an entirely different world, one of digitization, computerization, online research, video-assisted hearings, events like this. Online presence is what, 50 people or something, Amel told me. The last 10 years have borne witness to some of the most significant reforms in our courts, probably for over a century. A founding principle of the reform programme has been that in order to administer limited resources effectively, it's essential that cases are dealt with at the right level of court from the outset. So we now have a new judicial officer in the form of the summary sheriff. We have a new court at appellate level, the Sheriff Appeal Court, and another one in the All Scotland Personal Injury Court. I think it's also fair to say that there's been an increase in the variety of legal work available to judges at all levels, even if it be the case at the same time that the vast increase in sexual and domestic abuse cases, including historic cases, has limited the time available for judges to attend to that other work. We're seeing a number of successful initiatives at the moment driving efficiencies in the system. The summary case management pilot has been a great success. It's estimated that 530 summary trials did not require to be fixed. So in other words, we saved the need to have 530 trials in the pilot courts directly as a result of early resolution coming from. If you took that to a countrywide approach, which is where we're heading, that would have been a saving of over 3,000 trials. The volume of outstanding scheduled trials reduced by 31% in the pilot courts at the same time as it went up 10% in the other courts. So it kind of speaks for itself. An estimated 18,000 witnesses didn't need to be cited. Countrywide, that would be nearly 90,000. And further development of that pilot to other parts of the country, accompanied by detailed evaluation measures and a national practice note, is on the cards. In the solemn field, there's also a criminal courts practice note in the Sheriff Court designed to address recurring problems and efficiencies in the management of solemn business, building on some of the successes that the High Court has had in that regard and mirroring the case management at the heart of the summary case management pilot. Case management is a common feature of judicial work these days, something that didn't exist when I came to the bar. And we all know that it's effective in a wide variety of cases and as an important tool in achieving efficiency within the system. Experience has shown, I think, that the best handling techniques for long criminal trials is continuous management by an experienced judge nominated for that purpose, together with early involvement of the trial AD. There are a number of efficiencies that result as a consequence of that, and to encourage it, we now have a protocol for long trials designed to achieve that as far as possible. Another major change in the offering, we hope, is the creation of a national sex crimes course. That stems from a recommendation made in the review which I chaired, with the intention of building on advances already made in the way evidence of vulnerable witnesses is taken. The High Court Practice Note number 1 of 2017 that came out of the Evidence and Procedure Review was the real catalyst for change here. Before that, the number of applications being granted for commissions was negligible, but between 2017 and 2023, there was more than a 20-fold increase in the number granted in the High Court, going from about 30-ish to 750, and we're now probably over 1,000. Qualitative evidence confirms that the effect of that practice note was to reduce considerably the amount of time it takes for complainants to give their evidence, and shown that it is entirely feasible for the rights of the accused to be vindicated by sensitive cross-examination, and for that to take place out with the presence of the jury. They've shown it's possible to challenge reliability and credibility in a way which is calm, measured, and respectful. That practice note has now been reissued in an updated version, which reflects experience since we introduced that initial one. And it's hoped that these kind of features with detailed case management and trauma-informed training across the board will be at the heart of the new court when it's established. Of course, on the review, we knew it would take some time for the new court to be established, and we couldn't wait for progress to be made with the proposals for a new court before making such improvements as we could within the system. We recognised that proactive steps had to be taken to improve jury involvement and understanding. There was a pressing need to communicate information to juries regarding certain common rape myths and stereotypes, to encourage greater jury note-taking, to tell juries to review their notes prior to starting the deliberations, to make sure that everyone was involved in the discussion, to give written directions at the start of the trial to assist with understanding of the proceedings as they develop, all using language in as plain a form as possible. And these changes have all been put into place with, we hope, improvements in the way in which juries become involved and in their understanding of the proceeding. All of these reforms from Bonamy onwards have been vitally important, but they do share two important features. First is that for the most part they've been developed in collaboration with other participants in the justice system, and second, they've been accompanied and in some cases initiated from significant changes in judicial culture. This was something which was noted by Sheriff Principal Anwar in her forward to the SEM evaluation, that successful change involves planning, preparation, engagement, communication and evaluation across the board. And that's been the approach underlying virtually all the reforms I've mentioned. It was a principle of the various stages of the evidence and procedure review, of the development of the various practice notes and protocols I've referred to, and the work of the Sexual Offences Review Group. Working together in a constructive manner, we can achieve a much more successful outcome than if we merely try to impose things on others. And in a way, that reflects a change in judicial culture. When I started out, judges were effectively passive arbiters with startlingly little responsibility for the efficiency of the system they were operating. Gone are the days in which the judge or sheriff took very little interest in the progress of business. There's no longer any room for the traditional view that the pace of litigation is down to the whims and desires of the parties. The court must take an important role in making sure that efficiencies are carried out and that litigation is conducted with dispatch, without losing sight, of course, of the important issues at the heart of the cases. I think that for the most part, modern judges have proven themselves to be more proactive in that regard, and that modern case management is actually at the heart of developing innovation, and a judicial culture is developing which seeks to solve problems, to improve accessibility, to identify the need for reform, and to lead the steps necessary to achieve it. These should all be parts of the armoury of the 21st century judge, invested in changing the culture and making sure our system is properly, efficiently and successfully working to meet the needs of our society. So turning to the concluding remarks, since this is a Women's Network event, I'd like to return to the earlier theme of my talk, namely the advancement of women within the profession. In my early days in the division, I've been in the division since 2012, we had 4 women members. That was before we were outnumbered by men called Colin. We now have only 2. There's a total of 9 female judges in the High Court and the Court of Session, a number which has been fairly constant in the last 8 years or so. It's disappointing that this number has not increased over that time. Here's the most recent portrait of the bench and bar, and it's still a pretty male-dominated picture that you can see there. I really don't know what we need to do to persuade the successful women at the bar, that a judicial career is for them. I have spoken to a number who have been surprised at the suggestion, and I recollect reading that a man will apply for a job if he thinks he meets something like 40% of the criteria for the post. But a woman will only apply if she thinks she meets 100% of the criteria. So I think we need to change that, ladies, and be a bit more adventurous and a bit more forthright in putting ourselves forward. At a recent Commonwealth Law Conference, the Dean spoke about this subject from the point of view of the bar and noted that in respect of women, although progress, however slow, had been made, the glass ceiling remained decidedly unsmashed. He pointed out there's never been a female Dean, there's never been a female Lord President, or a female Scottish member of the UK Supreme Court. He did point out advances which needed to be taken in both branches of the profession, and it's at least encouraging that the profession is seeking to address the problem. Throughout the last century, women in the profession have shown themselves to be smart, independent, and confident. They've shown themselves to be formidable in the roles of solicitor, counsel, silk, and judge. Far from being condescended to by epithets like housewife QC, they have shown repeatedly that they are capable of reaching the pinnacle of the profession. Who knows what they can't do in the future? I, however, will be not here. I will be on the high seas if I have my way, enjoying the sunshine of the West Coast, and as the second of those photographs perhaps hints at, farewell and thanks for all the fish.